Hello friends, in the series on the income tax cases, today we will discuss a very important issue about section 148 notices. As all we know that when the assessing officer receives any information from any outside agency, whether it is the agency of the own department like investigation wing, whether it is GST department, CBI, SFIO or any other information, then the assessing officer, after receiving the information, directly issues the notice to the assessee, and even they do not bother to verify that whether this information relate to the assessee or not. And sometimes it has been seen that the information even does not relate to the assessee, and in many cases it has been seen that whatever the amount are alleged, they are not exactly matching with the transactions of the assessee. So whether in those cases, if the notices are issued without verifying the information from those agencies, then what is the fate of those notices, and whether the issue of notices without verifying the information is a jurisdictional defect or not. This issue has been taken by the Kolkata ITAT in the case of R.S. Darshan, Singh Motor Car Finance Private Limited versus Income Tax Officer, and this case has been reported in 112 ITR Tribunal at page number 158. The date of the judgment is 2nd May 2024. In the present case, the learned assessing officer has the information in his hand that was received by him from the investigation wing, and the information was that the assessee has obtained some accommodation entry of an amount of rupees 35 lakh from an entry operator BT. The assessing officer, without verifying the credibility of that information, directly issued the notice to the assessee. This was for the assessment year 13-14. The assessee objected this notice by saying that the amount is not 35 lakh. I have a transaction with BT of an amount of rupees 20 lakh. So as far as the amount was concerned, the income tax officer was not sure that what is the amount. So his allegations were basically baseless and without verifying the information with him. The assessee objected it vehemently and said that in the previous assessment year 12-13 also the assessing officer has alleged that the assessee has taken accommodation entry. In the previous assessment year, the assessee has proved beyond doubt the identity and the genuineness of the transaction, and the revenue has accepted that transaction in the assessment order of the previous assessment year. But the learned assessing officer did not consider the objections of the assessee and go ahead with the assessment and made the additions. And more importantly, as usual, the Commissioner of Income Tax Appeal also upheld the order of the assessing officer. It has been seen that even the CIT appeals in those cases where there is allegation from some investigation wing or from any other agency, even the CIT appeals do not consider the appeals of the assessee. The assessee moved to the ITAT, and the ITAT said that in the present case, whatever the information was available with the learned assessing officer could not be said to be credible information because the amount involved was 20 lakh and the learned assessing officer was alleging that it is 35 lakh. Tribunal also said that in the present case, the learned assessing officer did not examine the basis and material of information and has accepted the information in a mechanical manner. The tribunal said that in the present case, the notice issued by the learned assessing officer is illegal, wrong and quashed, and so the tribunal quashed the entire proceedings which were taken against the assessee. So friends, if we take some logic from this case is that the assessing officer cannot take all the information received by him as a gospel truth, and he cannot issue the notices without verifying the information. At the end of this video, once again I am repeating the name of the case. The name of the case is RS Darshan Singh Motor Car Finance Private Limited versus Income Tax Officer, and this case has been reported in 112 ITR Tribunal at page number 158, and the date of the judgment is 2nd May 2024, and the matter has been decided by Kolkata ITAT B bench. Thank you, friends.